Good morning, I'm Jason Chapman. I'm an Ombudsman at the Legal Ombudsman. The Legal Ombudsman investigates complaints by people who've received a legal service from solicitors and barristers. Today I'll be talking about litigation complaints. These don't include personal injury or clinical negligence complaints, but litigation complaints themselves account for around 500 to 600 complaints a year, or around 10% of the complaints that we receive in total. The most common types of complaints we see in litigation relate to costs themselves and cost information. We also see cases where the complaints have been raised because firms have failed to progress a case or a matter in the way that the client would expect. The thing we see a lot of is that cost estimate information isn't provided or updated as we would expect. We appreciate that it's very difficult for a firm of solicitors or indeed a barrister to provide an accurate cost information at the outset, because it's very difficult to understand how and when a claim will settle, whether it's just going to settle by negotiation at an early stage, or whether it's going to need to go all the way through mediation to court hearings. Obviously, the cost difference between an early settlement and a final court hearing can be tens of thousands of pounds. We don't expect a firm of solicitors to be able to provide an accurate estimate at the outset, but what we would do is expect them to provide information that would enable the client to make an informed choice about how to proceed. Therefore, at the first stages, we would expect the estimate to be provided for the initial stages of the litigation, and this could be updated as matters progress. The other thing that we find that firms don't make clients aware of is potential disbursement costs, such as the cost of barristers' fees, which can run into tens of thousands of pounds. What we'd expect is for the firm to make the client aware so there's no surprises at the end and they're able to sort of track their costs throughout. Therefore, as the matter progresses, we would expect to see updated cost estimates as appropriate, provided throughout the term of the retainer. We'd also expect to see a firm provide a cost-benefit analysis of the claim at the outset. Obviously, it's very different if somebody's a claimant in a litigation matter to a defendant, but even defendants have the opportunity to settle at an early stage, and a claimant has the ability to withdraw from the litigation if they wish to do so. So what we'd expect to see is for a firm to provide information on the likely value of the claim and in comparison to their own costs. What we look for when we investigate these sorts of complaints is that the cost information has been provided, including estimates and cost-benefit analysis, and that the case has been progressed in a reasonable manner. What the Legal Ombudsman does is seek to put the complainant back in the position that they would have been in had poor service not been provided. So if we do see poor service, we would look to remedy this. We do that by way of waiver of fees or refund of fees already paid, or we can direct a firm to pay compensation payments if there's been distress and inconvenience caused as a consequence of the firm's poor service. The issue is always communication. Provide the cost estimate information at the outset, provide the cost benefit analysis, provide regular invoices so the client's always aware of what they're paying and how much they've paid to date and what they can expect to pay. And update the client in regard to progression of a matter and when, for example, the claim's been particularised, any court dates in good time, so the client's got a good idea of the way that the case is progressing. Thanks for watching. I hope you found this useful. Further information is provided on our website www.legalombudsman.org.uk, and there's information on there on how we determine complaints and some of the remedies that we direct. Thank you and goodbye.